My dream was that the judgment in the Fifth Amendment case would be looked at by others in another 100 years, like I looked at Tonga 100 years after her constitution, and they will say that Bangladesh has been civilized for over 100 years. Bismillahirrahmanirrahim. It is a great honor for me to be here with you this afternoon. It is really a unique opportunity for me as an advocate to address at the same time the Honorable Speaker of the Bangladesh Parliament, the Chief Justice of Bangladesh, the Chief Justice of Nepal, a Justice from the Kingdom of Bhutan, several retired Chief Justices of Bangladesh, the judges of both the divisions of the Supreme Court, in other words, the full court, as we normally say it is, the Attorney General of Bangladesh, and my very dear senior and junior colleagues at the bar and the delegates of this conference. So, Madam Speaker, my Lord Chief Justice of Bangladesh, my Lord the Chief Justice of Nepal, my Lord the Justice of the High Court of Bhutan, my lords and ladies of both the divisions, judges of the Appellate Division and the High Court Division, and the Attorney General of Bangladesh, and colleagues and delegates. With your permission, I commence my speech. I start with a little story which I related to the Appellate Division in the Fifth Amendment case, which I will talk about very briefly today. It is a love story. But my love story, and it's not a love story with a woman, it is my love for the supremacy of the Constitution. I found in my researches that there is a small island in the South Pacific known as Tonga, which had a constitution adopted in 1875, nearly 100 years before us. Delving into the reasons, I found that the then monarch, the King of Tonga, was very worried about being colonized by the Western powers. He wanted to keep Tonga free for Tongans. And of course, he wanted to preserve the monarchy for his successors. He traveled around the world for a solution, sailing across oceans. At that time, there were no airplanes. He was advised by a friend, a New Zealand journalist, that to avoid being colonized, Tonga must be regarded as civilized by the Western powers. And to be civilized, not only do you need to look Western, but you must have a constitution as well. So the monarch, who was an absolute sovereign, whose word was law, adopted a constitution in 1875 and made himself subject to the constitution. Armed with that constitution and a treaty with Great Britain, the King of Tonga was successful in establishing Tonga as a civilized nation, and he avoided being colonized. Tonga was never colonized. That is a very important lesson that I think we can draw from there. I turn now to John Rawls and his theory of justice, which started the dialogue on institutional fairness, and which is basically the theme, as I understand it, of this conference. In his book, he is looking for a just society with fair institutions, protecting rights of citizens and others, and distributing the state's resources fairly. In that context, he is grappling with the concept of justice. He starts with what he calls the original position. He writes, "Thus, we are to imagine that those who engage in social cooperation choose together in one joint act the principles which are to assign basic rights and duties and to determine the division of social benefits. Men are to decide in advance how they are to regulate their claims against one another and what is to be the foundation charter of their society. Just as each person must decide by rational reflection what constitutes his good, that is, the system of ends which it is rational for him to pursue, so a group of persons must decide once and for all what is to count among them as just and unjust. This is a hypothetical situation. John Rawls was dealing with a hypothetical situation where members of the society agree on the principles of justice. For us who practice law, the theory of justice is not that important. For us, the practical aspects of justice are important. Rawls also writes, among the essential features of this situation is that no one knows his place in society, his class position or social status, nor does anyone know his fortune in the distribution of natural assets and ability, his intelligence, strength, and the like. I shall even assume that the parties do not know their conception of the good or the special physiological propensities. The principles of justice are chosen behind a veil of ignorance. Our starting position in our republic is the Constitution. That is the supreme law. We have our constitutions, Bangladesh, Nepal, Bhutan, indeed the whole subcontinent has written constitutions. In contrast to Rawls, who is dealing with a hypothetical situation, we are not dealing with a society behind the veil of ignorance. In our constitution, we are dealing with the stark realities of the effects of colonization, of domination, discrimination, oppression, and exploitation. These are all recorded in the preamble of our constitution, and why we, the people of Bangladesh, give ourselves this constitution. We decided that the solution of getting rid of the evils of the past and to be truly free, we must work together. And we decided and wrote in the Constitution that all power must belong to us, the people of Bangladesh, and that our power should be exercised by our representatives elected in accordance with law. We decided the fundamental principles of state policy and gave ourselves rights and obligations in our Constitution. We recorded what we needed to regulate our behavior in society and gave ourselves fundamental rights. Again, in contrast to Rawls, our starting point is different. We're dealing with real situations, not hypothetical ones. However, the objective is the same. We also want a just society, free from discrimination, free from oppression, exploitation, and injustice. Rawls treats justice and fairness as synonymous, and the learned Chief Justice of Nepal agreed that this is the case as far as he is concerned. I also agree. And Rawls states categorically that all state institutions must also be fair. As practitioners dealing with real-life situations, we agree with Rawls. We emphasize that fairness must exist in the justice delivery system. We regard that right to justice is the most fundamental of fundamental rights. Our Constitution gives us that right in Article 44. And I'm happy to hear that Nepal has also done the same. We also have the enforcement mechanism of fundamental rights in Article 102, which establishes a very robust and far-reaching system to protect fundamental rights and to enforce the law of the land. Casting an eye 6 time zones towards England, we look at the Report on Access to Justice by Lord Wolfe, which he prepared in 1994. He identified 2 evils in the justice delivery system in England: delay and costs. The Civil Procedure Rules, which was adopted on the basis of the Wolfe Report, states certain overriding objectives. One of the overriding objectives is to deal with a case expeditiously and fairly. My view is that our Constitution has the correct framework for building a just and fair society. The question is whether our Constitution has achieved that objective looking back over the last 50-odd years of our existence. The answer is yes, and sadly no as well. We have seen the worst form of derogation from our Constitution during what I have labeled a period of delinquency. In this, Bangladesh is not unique. My researches show that many countries in the world, while developing into maturity, go through one or more periods of delinquency, similar to the life of a human being when we use the words, the act of a juvenile delinquent. In my words, a period of delinquency occurs when we depart from the written and agreed principles in the supreme law of the country in our Constitution. In 1975, when our father of the nation was brutally murdered, together with all members of his family, except our Prime Minister and her sister, there started a period of delinquency, when the Republic's power structure was dramatically changed and martial law was imposed. The constitutional processes were derailed, and a new form of government came into existence. During this time, the Supreme Court failed the people of Bangladesh and gave decisions where they coined phrases like martial law is supra-constitutional, martial law eclipses the Constitution, etc. Justification for martial law was based on the doctrine of necessity. Written originally by Bracton, but later propounded by Hans Kelsen, it was based on the maxim solus populi est suprema lex, the safety of the people is the supreme law. Many countries have resorted to this maxim and the doctrine of necessity to legalize what in many situations would have been plainly illegal. The doctrine was first adopted by the Supreme Court of Pakistan in 1955 and later used to justify the imposition of martial law. Martial law lasted in our country, in Bangladesh, for over 16 years. In 1991, the people of Bangladesh unified, agitated together to end illegal regimes using the armed forces. I'm happy to say that our faith in our justice delivery system was restored by the Fifth Amendment case, also referred to colloquially as the Moon Cinema case. In declaring martial law as illegal, our Supreme Court accepted my submission and stated in its judgment. So this court, and I quote, so this court should not, indeed cannot, grant leave in these cases because to do so would be perceived by the people of Bangladesh in the way that our highest judiciary is still unable, long after the period of delinquency, to properly and adequately deal with such delinquents. And further, it would send wrong signals to those who wish to circumvent the will of the people in the Constitution. And that each of our generations must also be taught, educated, and informed about those dark days. The easiest way of doing this is to recognize our errors of the past and reflect these sentiments in the judgments of this court, which will ensure preservation of the sovereignty of we, the people of Bangladesh, forever as a true Pole Star. The doctrine of necessity was finally buried by our Supreme Court in 2011 in the Truth Commission case, in which I appeared and supported the doctrine of necessity. That was basically to throw a challenge to the Supreme Court. And in fact, the Appellate Division in its judgment said that no more reliance on the doctrine of necessity would now hopefully be necessary, and no further indulgence of condonation of past and close transactions would even be prayed for. In this way, our Supreme Court has delivered many landmark judgments which have established the supremacy of the Constitution. I'm happy to say, in the Seventh Amendment case, where I was one of the amici curiae, which dealt with the second period of delinquency under martial law, the Supreme Court expressly overruled 4 of its previous judgments where martial law was previously justified. Coming back to the issue of justice and fairness and our justice delivery system, we have seen derailment from the constitutional framework and also the restoration of the Constitution. I will end with what I told the Supreme Court in ending my submission in the Fifth Amendment case. I said, my dream was that the judgment in the Fifth Amendment case would be looked at by others in another 100 years, like I looked at Tonga 100 years after our Constitution, and they will say that Bangladesh has been civilized for over 100 years. My lords, ladies and gentlemen, our dream has been made true by our Supreme Court. May it prosper and help Bangladesh prosper forever under our Constitution. Thank you very much.